May I be permitted to make a mention? My lord, this relates to PG dental PG counseling in Stored. My lord, listing. I today. I am filing today because the improved order has been passed on Sunday, last Sunday, and the counseling they have reopened the registration from today evening. Actually, I want if it is possible at any time. The registration is for how many days? My lord, registration is already over. We have registered. They have rescheduled now. You got the registration in your statement. My lord. That's how the response is. The reopening will continue till when? My lord, it starts from today. Exactly, sir. That's not the response. My lord, I am challenging that rescheduling. So yeah, so that's no urgency. Because my lord, you cannot dictate terms. No, it is against the today. Next day, it shall be taken up tomorrow after you remove the tomorrow. My lord, please stop walking on the side. Again. My lord, my case is, my lord, it is petitioner is respondent is aged about 78 years for listing, my lord. I may be permitted to make a mention, my lord. Honorable Court had directed the matter to get listed within 2 weeks. 2 weeks has expired on 4/7/2020. One matter, my lord. One matter, my lord. Case submission, my lord. Let it come in. Yes. My lord. My lord. My lord, this matter is remanded from the Honorable Supreme Court. It was listing for a year. Face admission, let it come just
Your Lordship, fresh admission. Maybe take it. Yes, Your Lordship. That, Your Lordship, next week, maybe. Oh, please, Your Lordship.
Yes, admission rate of Your Lordship. I prefer listing. Urgency, he will
Your Lordship says admission. Fresh admission.
Page 3, 11 to 14. Page 15, page 4, 15 to 22. Page 5, 23 to 27.
Pardon to make a mention, my lord. Your Lordship, item 26, I may be permitted to withdraw with liberty. Yes, Your Lordship. Your Lordship, actually, the matter has become infructuous because in the meantime, there is 26. Yes, Your Lordship. Appellant. Published.
I don't know. Item 15. Item 15 kindly taken on next week, madam. Yes, madam. 1-5. Yes, madam. Yes, madam. My copy I saw yesterday.
Not for the respondent.
Yes, madam. Yes, madam. Yes, madam.
Okay.
Yes, madam. Yes.
Second week of August. Yes.
Page 6, 28 to 31.
I may be pardoned, my lord. Item number 30. I feel that Mr. Senior Counsel, Mr. S.S. Starks, is having some personal difficulty. Maybe take care of next week, my lord.
The other side.
Other side is the state, I think so. I have not informed. Other side is the state, my lord.
Yes, further, they are asking for the state in second week of August.
Maybe taken about 15th or 16th.
No. We are being part this part time.
Second week of August.
In the from the open funds.
Mine. Obliged, my lord.
Page 7, 32 to 35. Page 8, 36 to 40.
40, you can. I am for respondent. I have taken consent from my brother friend. My personal difficulties. Yes, I am for respondent.
What's that?
Yes, you're going to regarding item number 39.
39.
SIP had earlier directed on 1st of July to be present with the girl child's father. They have law.
The fathership, the wife is unable to come to the fathership due to bus strike. It is in distance, yes, 130 kilometers to distance with the village in Keonjhar district. Due to bus strike indefinite period, she is unable to.
How come?
They are residing at Katta scholarship.
They are selling credit.
Yes, yes.
Then must have to stay.
If indefinite period strike is there, scholarship may keep it to accept her.
Right. And from say we use the order the main proceedings, the main proceedings from which the input pages are stated to have been finally scored out. While order date in certain.
Item 35, Jim, what is in the
Yes. Then appeal better. Further. I don't know. Anything further? Nothing wrong there. Okay. Topic on.
The proceedings from the order are the import payment how they will be disposed of. Therefore, this type that is relevant in to us. February 2018. Should be like the argument is stated that any payments in respect of an engineering order by making it a ground, by making a challenge to the order, whereby their proceedings is scored off. In line with the rule enacted in order 43, rule capital 1 capital A, 1 capital A, as amended by CPC 1976.
By the 1976 Amendment Act. First, with the above observations.
The registrar judicial shall take note of the fact that a wrong disposal date has been mentioned in the cause list. Instead of 9th February 2018, being the date of disposal. The date of disposal is mentioned as 28/7/2006. Shall instruct the concerned superintendent of the KSO accordingly.
Yes.
Item 3,
For the appellant has filed in the open court the stay seeking leave of the court to withdraw the appeal. First off, the short memo reads as under. Next paragraph. Any objection from the other side? Other side not served. Fresh matter.
Not served.
Fresh matter. Appeal. Yes. Appeal is disposed of as having been withdrawn in terms of memo. Next.
item 4,
My lord, extremely sorry, I beg. I'm extremely sorry, I beg apology for that. Yesterday it was listed, I was under the impression that this writ appeal was dismissed for default, it was not been restored. My lord, it was restored. So now, my lord, your lordship, my lord, so extremely sorry for that, your lordship. In the outset, my lord, now this case, appeal is for fresh admission, your lordship. Impugned order, your lordship, kindly see that is Annexure 7, starts with page 50. Your lordship, two grounds are taken that one, the learned single judge, your lordship will see that the person who has committed the irregularity and wrong has again sent this matter to dispose of that officer. Well, your lordship, advertisement was made to fill up the 5 posts of revenue inspector. I am in serial number 4 of the select list. Serial number 9, which is a lady candidate, SCBC woman candidate, she was given appointment. Then I challenged that no, her quota has been filled up, so I should be given appointment. That is under challenge before the learned single judge. Learned single judge, your lordship will see, he again. No, that is, she was in serial number 9. I am in serial number 4. So I am also general category. She is SCBC female. Your lordship kindly say that is writ petition advertisement, that is Annexure 1, page 16. Writ petition, your lordship. That is Annexure 1, your lordship will see. Annexure 1 is the entire writ petition.
2020.
My lord, 13, your lordship. All right, your lordship. My lord. My lord, so only 3 in case of woman category. W, your lordship, kindly see in the column. Number of vacancies, did my lordship get it? That is, yes, my lord. Revenue inspector, your lordship. My lord. My lord. That only the. No, that. Your lordship, kindly see. And my lord. My lord, advertisement. No, that is yes, your lordship.
I am SCBC
My lord, I am clarifying, your lordship. I am SCBC male, but there is no such stipulation that is SCBC male. Only SCBC 2 posts, SCBC woman 3 posts. That is, and your lordship kindly see. My lord. No, that is vertical reservation for your lordship SC. Horizontal, my lord. That my lord. Horizontal, my lord. Then your lord, just have a glance to Annexure 5, page 22. My lord. Your lordship. My lord, your lordship kindly see Annexure 5, page 22. Annexure 5 is the select list and they have application form, your lordship, that is annexure 3 is the admit card, annexure 4, your lordship will see admit card component. Minor. No, I am not. Annex. Your lordship, that is annexure 5 page. That is, that is document of the, my lord, that is your lordship, I will explain. My lord. No, your lordship, that 6 point, your lordship, kind of 6.8 of the read petition, your lordship will see. Why not take it that one to category? Your lordship, the applicant had secured applicant has applied it one to category. My lord. And my lord, that is 6.2, your lordship will see. Not it is stated that although it is not stated as a SCBC man for 2 vacancies in the advertisement, it is required to be understood as such notification. The applicant applied for the post of revenue inspector, giving all details required under advertisement, and he has issued admit card, call letter, etc. That was not mentioned. My lord. Then your lordship kindly see.
You're asking one sentence.
My lord.
That also.
Enter only one page, your lordship, that will clarify entire issue. That is page 22, annexure 5. That is the select list and all particulars.
Select list is fine, sir.
Unless
you belong to SCBC category, your caste has to be there. Caste certificate has to be there. It has to be recent Supreme Court decision. Central OBC list will not be also applicable. So you have to build up your case on that you are a SCBC candidate, state notified SCBC category, applied as SCBC category, and could not get. That's it.
No, his case is even otherwise. His status he has given up. Kindly come to space 14 of W. Paragraph 6.11. 6.11. 10 last part, ultimate part. This is submitted here that even if the 2 posts are to be taken as SCBC by not reserving for men or women, still then the applicant having secured 286 marks will come up in merit list as the 5th selected candidate.
That's the wrong statement, Mr. Mohanty. That's a wrong statement.
This statement is
inference.
On the basis of the document.
Merit may be tougher.
My lord.
But you do not know the category because advertised vacancy we cannot change.
My lord, that is your lordship.
Unless you challenge the advertisement itself that there is vacancy for general category and not advertised, so that they can answer. It is in your favor actually. The discussion is about your case. State will answer that. Suppose state answer that yes, there are general category vacancies.
No general category vacancies at all.
Advertised. That's the problem.
That is your lordship. May I draw your lordship?
No, where is your right to be in the fray? Apex Court said, right to be in the fray for unreserved candidate does not avail where vacancy is notified or not unreserved.
Because there is no reservation.
Enter the fray. One single sentence. This infra-court appeal seeks to call in question a learned single judge's order dated so whereby appellant's WP number so and so has been negative. There is nothing in it.
No, may I interrupt only? What are the lacunas or flaws?
Where is the question of lacuna? Because we understand, we have understood your case now. What we are saying is, unless there are your category, how can you be in the fray? Assuming there are 100 and odd mistakes in this one. That we are asking you.
Only one point, that is, I am admitted, I am a SCBC candidate.
Who has admitted it?
That is in the counter, they are not disputing.
Where have you stated to dispute? Question of disputing arises where you have averred it in your petition, not otherwise. There is no such averment.
So that is for that reason, again and again, I am drawing your lordship's attention to Annexure 5 of the writ petition, page 22.
Mr. Mahanti,
My lord.
would require further assistance.
My
Look at page 21 of the counter.
My lord, come, your lordship.
That is running page 21 of the brief, I think.
My lord.
21. Sir.
My lord. That is a
Can you
admit
read
card.
the paragraph 2 of the counter slowly?
My lord.
It starts at 20 actually, so it will get disjoint. So you start reading para 2. The governments made in para 6.8 deserves no consideration, or you are not getting it.
Annexure 2, page 28.
Page 28.
Yeah, but he is referring to the petition. He is not referring to the appeal. I asked him that which brief is the.
My lord.
Whenever you get the counter, kindly take this.
No, my lord, that's not. Out of 5 posts of army.
So read that. Read it aloud. The governments. Yes, sir. No, there. That was 21.
Governments made in para 6.1 to 6.7. No reply.
6.8 deserves no consideration due to the fact that 5 posts of RI meant for SCBC candidates, 3 posts were meant for female candidate, other 2 posts were meant for SCBC candidates, and the same is not for SCBC male candidate, and hence the vacancies were
Over.
order of merit.
Very specific stand.
My lord.
Reproduction is that way, then they will have answered. We can't improve. There is scope for improvement even in our.
My lord.
That is no problem for giving permission to improve this area. So what are your marks? What were your marks?
That is page 22 of the writ petition. Your lordship. 28. My lord. Numerical first, your lordship. My lord, I have secured 286.
286, you have secured. Whereas respondent number 2, we have secured 194.
Obliged, your lordship.
But question is not that.
Madam.
Question is of status. If it is poor, we have understood. No, nothing is earmarked for your case. And your case, specific case that you belong to a particular social state.
My lord, obliged.
Otherwise, you have.
My lord,
How many candidates were engaged?
4, your lordship. 4, your lordship. Out of 5 advertisement vacancies, 4 women given appointment.
Yeah.
My lord, 3 women. Thereafter,
So the 4th lady, how much is secured?
194 mark she has secured. I have secured 286.
Very good. Okay, and this reputation is kept pending, or we have you never forget appearing immediately. Let me do it, please. Very sure this is. There's one point. Which my brother is saying. It makes sense. We should this. That's fine.
Respondent.
Private respondent is there.
Private respondent is 2, only 1.
My lord.
One.
1.
One.
Can you share the papers with the
My lord.
fingerprints?
Read it. My lord. My lord.
Yes.
Item 6.
My lord, I pray for a Passover, my lord. My lord.
Item 7.
It must be yours. No.
Yeah.
People challenged.
Yes, Mr. Marji. What is
Challenge the judgment dated 16/8/2024 of the Honorable Single Judge directing for de novo inquiry again in a disciplinary proceeding after the inquiry was conducted twice and punishment was used.
Twice it was conducted.
Twice the inquiry was conducted.
In the first inquiry, you give the details of
My
first
lord,
inquiry.
my lord, your lordship, can you see?
First
that-
inquiry was concluded when?
Well, first inquiry was concluded. Inquiry report was submitted on
16/3/2018. What it said?
31/5/2016, my lord.
Guilty of
The first inquiry report was submitted on on 31/5/2016, my lord.
What happened to that inquiry report?
That the inquiry officer suggested for recovery of 12,58,313 and withholding of 25% of pension for 5 years, my lord. That inquiry was conducted, my lord, without examining a witness, without exhibiting any document.
That's all.
and without-
What the disciplinary authority said? He agreed with the...
No, I made the inquiry report was communicated to me to file the show cause. I filed the show cause, first representation. And taking into account that first representation and my contention, the inquiry of the disciplinary authority directed for second inquiry.
He ordered for second inquiry.
Second inquiry.
That was ordered on?
That was ordered on. It was ordered on 31/12/2016, my lord.
On what ground he said?
That no opportunity was provided.
No opportunity was not given.
Yes, my lord. That is Annexure 6, my lord. At page 53, you will also find.
Then what happened?
Then inquiry was conducted, my lord. The witnesses mentioned in the memorandum of charges, those witnesses except one who had conducted the preliminary inquiry, he was examined by the inquiry officer, cross-examined by me, and I examined 4 witnesses. Those are cross-examined by the inquiry officer, not by the marshalling officer. Therefore, on the basis of that inquiry report, I filed the show cause. Losses can come to page.
No, that inquiry report said what?
That on the basis of earlier inquiry, that was quoted, and same suggestion was given by inquiry officer. Entirely, the first inquiry report was quoted in the second inquiry.
Not quoted, in the sense it is referred to first inquiry.
No, entire, my lord, the language was also quoted. That only re-inquiry, no further fresh findings or fresh materials were brought on record in the inquiry report, and the same suggestion was given. I made the representation, my lord, to the inquiry report. To notice, kindly come to annexure. That the inquiry officer is biased.
Huh?
I submitted that inquiry officer is completely biased, and the witness material witnesses were not examined. That preliminary inquiry report on the basis of which the charges are framed, that was not exhibited, my lord. I challenge that before honorable single judge. I made submission on the basis of the same that the punishment imposed on me was cost.
And matter is remitted for
remitted back. My humble commission.
Because you said it's a biased inquiry, then we wanted an unbiased inquiry. We said hold unbiased inquiry.
My lord, but I retired on 2017.
You might have retired.
My lord, I challenge on another ground, my lord. That on the basis of preliminary inquiry dated 18/11/2013, conducted by SCF, Nayagarh, where no opportunity was given to me.
No, need not be given.
Need. And behind my back, that inquiry was conducted. On the basis of that inquiry report, the charges were framed by
correct. Preliminary inquiry. Apex court said preliminary inquiry does not involve the delinquent employee.
The latest law is that if the statute does not provide for a preliminary inquiry, and preliminary inquiry is conducted and basing on which the charges are framed, my lord, that is not sustainable.
What Justice Ramajoyce writes in his book is, a preliminary inquiry is held to decide the worthiness of worthiness of the
lacuna again and again, my lord, that inquiry is conducted, that inquiry to not certain. Twice I faced the
again
inquiry.
and again means
now
not that again.
Now 8 years, my lord, they did not exhibit the preliminary inquiry.
Your first proposition.
Yes, my lord.
No preliminary
inquiry.
inquiry.
Can come to para 11, my lord.
Yeah.
I'm placing for enter 2-3 paragraphs, then it will be clear, my lord. That is 2021-17 SEC, my lord, page 90. At page, my lord, it is at page 11 para 11, my lord, 94, my lord. Let me place, my lord. It is admitted by the learned counsel for the appellant that there is no provision for preliminary inquiry in All India Services Disciplinary Appeal Rule.
Here also, in your case also, no provision for preliminary inquiry.
There in the CCA rule of 2000.
Is it true? No preliminary inquiry can be held?
No. There is no provision.
Which is the rule?
Preliminary
that is the Odisha Civil Service.
Whether they can proceed with the
We are
inquiry.
repeating what I have said.
Odisha Civil Service, my lord. Odisha Civil.
We are asking
Yes, sorry, my lord.
See, brother, what he says is, in the absence of enabling provision in your discipline rules, CCA rules, you can't hold preliminary inquiry. Appears to be the ruling. Appears to be a ruling. There are many conditions which will examine. What is the position in rule position?
I'll check it, my lord, because in absence of any rules, whether it can be.
If you could say, it cannot, this is the latest position, is the version not for you.
Yes.
We are asking a simple question. Whether there is any provision in your CCA rules which enables the government to hold a
preliminary inquiry.
Where is the preparation from your side?
I'm sorry.
Government side, there should be assistance.
I'll check it now. And apprise your lordship.
So what is the matter?
Only. Come Odisha. Relied upon that 1964 Supreme Court, my lord.
On a reference,
Kuta. 17.
Just looking to, and from what we expect, higher standards from government lawyers. Government has chosen you because of your purported competence. Private lawyers, private litigant will choose. So we have no say in the matter. But in respect of government advocate, you have to come to this court with full preparation. Otherwise, we may write in the order that there is no expected level of assistance from the government side.
I'll check it and apprise. I'm sorry, my lord.
Because government, why you are chosen out of thousands of lawyers? Only few are chosen by the government because of the human competence. But that is a assumption that they should be.
Yes. Hence, in your considered opinion, the preliminary inquiry as held in the present case could neither have been directed nor it is relied upon for framing the charges against the respondent. The authorities are proceeding the preliminary inquiry as if it was guilty finding exercise, not an exercise on formation of opinion. Here, their charge, here charge has not.
Yes, ma'am.
You should have links, you should come with full key. So there's a mechanical company that is the vehicle. That way you have to bring your law, you have to bring rulings, you have to bring opinion of the experts, literature.
On Monday, ma'am.
That is not happening. So that we will using our own
Research, that's
no accommodation. You are the springboard. If springboard is weak, there's nothing in jump on.
the populace, my lord. That is, your lordship is correct, absolutely correct.
About this matter,
Interim order, my lord. Interim order, right. No, that was the punishment was stayed, my lord.
But after retirement, what is the punishment?
Recovery. Recover that say. No, my lord. I have filed all the documents. They have given the certificate that document that I have completed all the works. I have annexed that. Yes. 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 That it was stipulated to be concluded within my lord stipulated period, my lord.
But the inquiry goes on, but no action shall be taken on the reporting level. The inquiry reporting level.
Your lordship.
Then proceedings go on.
Yes.
Item 8.
Lady young bank officer of Bank of Baroda. She was transferred from Odisha zone to Godhra zone.
How many kilometers?
In Gujarat, I don't know. Gujarat. Godhra in Gujarat.
State of Odisha differences.
My father is transferred is dated my lord 29/6/2019. There is a bank circular, yes, my lord. And no, not transfer. I am challenging the order of punishment, my lord. Yes. Unauthorized absence, they removed from service only on the ground of unauthorized absence, my lord. I didn't know. Where there is a bank circular, my lord. Bank circular, this routine exercise of transfer can be exempted in case of where there is a family member, handicapped member, and I am the sole caretaker, caregiver, my lord. And that benefit is given to all others, my lord.
No,
the bank. Bank.
After you go scale to scale.
Yes, ma'am.
You are liable to.
No, I am not. Yes, I agree to it. I am only on the way. I also turn to page 14 and it's to the bank circular, my lord.
Is 14.
Yes, ma'am. Bank circular, madam.
Paragraph.
First paragraph. In supervision of all.
Your case is you have a different dependent.
Yes, ma'am.
Who was?
My father, my lord.
Father.
I remain unmarried only to give care to her. Now, what only reason, my lord? Only in the counter affidavit, that was a document that is relied upon by the honorable single judge, which were disclosed not only in the counter affidavit.
Further hours state of Supreme Court. Take up that judgment. Because there are 1986, 1796, something. Further hours state of the Madhya. Next court says, if you have any grievance against the transfer, first you should report for duty. Then you make a representation to the government. You will apply, asking that we have this treatment. Therefore, the individual. If that is not considered, you have a cause of action. If that is not taken, you have a cause of action. Take out what are the hours in state of
Barodhara.
95, 96 to be.
Barodhara.
Barodhara. No researchers in the court went down. Even lawyers are doing.
Or state of Karnataka.
Number one. Number two, the transfer guidelines, violation of transfer guidelines, which does not give a coded cause of action.
Yes, I got it. But what they did, my lord, the inquiry.
1986. Yes, 86. No, you can sell and BC that. 86 Supreme Court 1955. That was segregation. Did you bring to their notice?
Yes, yes, ma'am. Yes, ma'am. Yes, ma'am. Yes, ma'am. Two, my lord. Daughters. Other married daughter.
Is married daughter?
Three, my lord. One son also there. He's not there. He's not supporting the family. He's remaining outside, staying outside, my lord. Staying separate from the family.
Where is your representation? Which I say to transfer is innovative.
Yes. Page 16 is my repentance. My repentance on Annex 3, page 16. Annex 3, page 16, my lord. I only to take care of my ailing father, I remain unmarried. As there is no other person in my family.
Which is the date of your transfer order?
Transfer on 29/6/2019.
In 2009.
Yes.
You sent the representation when?
Before transfer, proposal transfer, I submitted representation and I submitted the representation. After transfer also, I give a representation. My date set I have given, my lord.
You have permanently kept information.
No, my lord. Not my, for short period only. That is.
Where have you stated for short period?
That is, I have not subsequently.
Your father is Sahoo.
Yes.
Sahoo is another. Or externally you want to be.
No, not. That is yes, yes, no. What only point, my lord. Yes.
It is great that you are looking after your father. It is still greater that you remain unmarried because marriage will come in the way of you are looking after your father. But finally, not just
yes,
there is a son. There is a son. Where have you mentioned that son is not looking up? Where have you disclosed to your employer that there is son also?
During inquiry, I have disclosed. During inquiry, I disclosed. Repense I have not done.
Yes.
Only one. I took two grounds, my lord. Highly disproportionate. Had it been allowed upon retirement, my lord. The second ground, one ground. When in the dispute, Annex 2, it is not your disability does not come within the purview of Annex 2. That is the dispute, my lord. That dispute they disclosed that most after the inquiry, only in the counter affidavit. Only in the counter affidavit.
What fairness? Where will you fail the employer? You did not disclose that you have a brother. Under Indian law, even the Senior Citizens Act. At the heart, there are many other places.
My brother is not staying with the family.
Where have you stayed? Where have you stayed?
No.
It is duty of the father. It is actually evidence.
Yes. I
look after the person when he is in the evening of life. That very meaning is put there. Meaning itself. Therefore, in our scripture, it is saying.
Because I forced to remain unmarried because of the.
No, that's very good. Then leave the profession. Go there and look after the father.
Exactly. Because the lifestyle you are leading.
Yes.
And spending money for your father or for yourself. So that is all because of your job. Marriage could have helped you also.
Yes.
Because in a matrimonial home, you have more persons so that your
point is she has not disclosed also about father, about her son or brother, and brother being not virtuous. You should have disclosed to the employer. No, I have a brother.
I disclosed.
He's not looking after in your representation.
I disclosed in course of inquiry, my lord.
That's
one thing, my lord. The inquiry was conducted, my lord. So far the inquiry is concerned. The inquiry was concluded within 1 hour on the same day, while rule says when I disagree with them, then it has to be.
No, Mr. Malik, just be patient. Did you disagree with your unauthorized absence?
No.
How can you take
they should have taken 1 minute actually.
Yes, ma'am.
So unauthorized absence and disobedience of order.
No, this
not joining in the Godhra region. So if you dispute now, even also that can.
No, my lord.
So the question is, Mr. Malik, the question is actual prejudice. Actual prejudice you have to show now also.
On that point, I submitted representation to take the benefit of Annex 2 to exempt it, my lord. They kept silent for long period, my lord. They kept silent for.
It's a settled law. I don't remember the decision of the apex court.
The rule says, my lord. Rule says that through 3 allegations, my lord. Honest absence, I admitted, and 2 deliberate. Rule says 6.9. If the officer employee does not plead guilty, the inquiring authority shall adjourn the case to a later date not exceeding 30 days or within such extended time as may be granted by the inquiring authority.
So, Malik, we are accepting your contention. That is how the question. After that, you have to show by doing so,
yes,
what prejudice was caused to you.
Yes, madam. So now on the same day, the prejudice, I could not
see. Suppose they grant you 30 days time.
Yes,
what you would have shown?
What you would have shown, you have to show to the court now.
Yes, madam. I would have shown my the other persons, my lord, similarly situated persons have been allowed the benefit under the exemption of the
whether they had also son.
In similar situations,
question of similarity will arise where you are fair to the employer. You should have been fair to the employer, saying that even they have got a married son. Despite that, they have permitted him to draw the milk from particular circular. That is not your case. On the other hand, you do not want to, you took the risk of violating the transfer order. How the organization should, it's a bank.
On the point of disproportionate of punishment, my lord, only. And it means retirement, I would have taken.
How many years of service you have put in?
12 years, my lord.
12 years. Qualifying service, there is no pension, perhaps. Triple benefit scheme. Bank.
So nationalized bank, my lord.
Because we have
that part, my lord, let bank. On the during course of hearing before the single judge, bank advocate also succumb to that. They will consider regarding.
You said that way. You want to remove that person from the panel now?
No, fine. I don't take. Let him
issue emergent notice. In addition, first off, in addition to taking usual steps, the appellant to serve copy of the appeal memo along with all the documents on the learned panel counsel who represented the respondent bank before the learned single judge. Third week of,
but you have to make a lot of sacrifice.
Yes.
Can she enter again at the base level or at the level where she was? She can't get anything out of that 5 years because it's a serious allegation for such a senior officer. And absolutely no ground to interfere. Must understand.
But since you said she is looking after father, ailing father, though she was not paid to the employer. Anyway, let us see. Your advocacy played a gimmick with us, not the merits of the case.
Item 9.
Yeah.
Please, Your Lordships. Lord, here is a case because of the incoherence in action between the authorities like PCI, which is the Pharmacy Council, the state government, and the authority DMT, which grants the NOC. The lot of colleges, including the petitioner's college, have been debarred.
Identical matter?
No, my lord, this is slightly different. In that case, my lord, your lordships, because of your lordships intervention, in the other case, your lordships fixed for that second JE, OJE.
Correct.
They have now allowed also taken out the notification in the meantime. So,
mentioned and it will be disposed.
Yes, no, your lordships have fixed that the 17th we will be.
They are afraid of your tallness.
So
both at the bar and physical also. Yes.
Your lordships may come to the impugned order, which is at page 83.
Let us issue notice. Let us. Who are the parties? Union of India?
Union of India and
you all appeared now. Ready in the matter.
For the first time.
First time.
It will take time. Formal notice need not be issued. You file your appearance or what? File
Shri.
Appearance time.
So it's CGC.
Yes, ma'am.
CGC appears for first respondent UOI.
And 1 and 2. 1 and 2.
1 and 2. I am to 3 and 2. Shri. And so the panel counsel appears for 3 and 4. 3 and 2. 3 and 2. Only 4 respondents.
Yes,
when to have this? Any urgency?
My lord, the reason being that, my lord, the reason being the permission granted by the Supreme Court by changing the timeline on the application of PCI itself is now till 30th of September, but by 1st of August, they have to complete certain procedural aspects. So in the last...
Call it in the first week of August.
My lord, subject to lordship's convenience, can it be on 5th or 6th?
5th or 6th of August. Okay.
an additional affidavit we are filing where we are enclosing that NOC granted by the DMET and the Supreme Court's judgment, the orders. In fact, the interim orders where the timeline has been.
Additional affidavit accompanied by appellate court decision under which it is filed by the
PCI.
PCI.
There the PCI was the applicant in the
Now
APA.
produced before the court, and the same is taken on record.
Okay.
The pendency of this matter shall not come in the way of respondents, considering case of the.
No, my lord, they have already rejected.
Rejected only.
Already rejected.
Okay.
And predating the NOC and the affiliation, everything.
No, because of
reconsideration.
Reconsideration.
So can you use the word reconsidering?
We have not made any application since they have rejected. We can make the application, then they can reconsider in view of the Supreme Court.
Petitioner is permitted that
They have filed the appeal, so that reconsideration can
during the pendency of this petition, petitioner is permitted to.
No, appeal has already been filed.
Appeal.
Yes.
Appeal is filed.
Appeal has been filed.
Before PCI.
Before PCI.
The appeal shall be considered.
Then we will say this pendency of this petition shall not come in the way of hearing and disposal of the pending appeal filed by the petitioner before the Pharmacy Council of India.
OP number 2.
OP number 2. Okay. You tell them to dispose of the appeal in the meanwhile.
Lordship, sub-item 3 and 4 may be permitted to withdraw. I am filing the memo.
3 and 4.
Your Lordship, the matter has become infructuous because
the three sub-items, the first two is identical. The 3, 4 has become infructuous because of that
judgment
order and the
that should be referred here also. That in the order passed in so and so. They are included in the chain. We mentioned that writ petition.
Your Lordship,
In the memo, you should write it.
Your Lordship, I mentioned the rejection order.
No. That after the interim order passed, the orders passed in that other writ petition, so they have allowed UJE has allowed you to participate.
No, Your Lordship. This is rejection of NOC.
Rejection of NOC.
Learned counsel appearing for the petitioner has filed a memo dated 8/7/2025 seeking leave of the court to withdraw the filed a memo which reads as that. Next page. In view of the above, petition is disposed of as having become infructuous, reserving liberty to lay challenge to the rejection elsewhere in accordance with law.
They have already challenged. We have already
challenged also.
Already challenged that.
Anyway, we have given the liberty. Two methods. Huh? Okay.
Item 10.
Item 10, Your Lordship, the rejection of NOC, fresh NOC, Your Lordship.
Fresh NOC.
Your Lordship. In under Annex 9 at page 51, Your Lordship, the grounds of rejection has been mentioned.
Rejected on the ground?
Rejected on the ground, complete geotag photo of the institution from outside, not submitted.
Similar case of learned senior advocate other day. We
fixed
it to 15th now.
10th, Your Lordship, it has been fixed.
My Lord, the 10th.
Take notice.
No, my Lord. 10th, what is happening? The matters has given, my lords have given direction. 2 weeks time was given to give us the reply. Instead of 2 weeks date, the date was due to 10th. I have called for all the records and everything.
So let us see on that.
Yes,
Let us see. We will grant you time and no difficulty, sir.
Yes, I am bringing because I have to appraise my lord about this.
That's one.
The NOC and
all right. Issue notice. Learned AGA, Mr. Mohanty is requested. Mohanty or Panda? Who appears? State Mohanty appears for. Is requested to accept notice for first respondent. Then panel counsel, you are appearing
2 and 3, Mr. Arna.
2 and 3. You are represented by learned panel counsel Sri. Which date you want?
It was 17th or more.
Call this matter on 17th. 17th. Okay. Take this. Yes.
Item 11.
Yes, ma'am. In person. Yes, ma'am. Offenses are 458, 441, 365, 376, 2G, you know.
676 is also there.
Yes, ma'am.
G gang rape.
Delay of 135 days.
14% it's that the process sent by the court to police have been duly served on the accused. But how many accused persons?
2 persons are there.
In person.
Ranga and Babula.
Before the organization without research. Well, next part. All of the names.
Ganga Pradhan. Abula Pradhan.
Names of the accused are part of the law case, the court officer, or instruction. First, there is no response from them. First, next one. B is paid up for looking a short period of
35 days.
35 days. Now, the case of donation. Companies are being first, the proposal of the state shows that there is a public explanation of the DA2 person, even otherwise, the bill works on durable on dates. First,
The offences alleged against the accused persons is punishable under section 376 of IPC.
2G. 376 2G. It's a gang.
First one, in view of the above, the application having been favored, delay is condoned. Okay, let us see then what was
200 days delay.
200 days delay reported
delay of 200 days. Second, that what short can be removed? Making a delay of 200 days. The
short can be removed. Just 200 days. Yes.
Against the order, wherein the Honorable Single Judge Lord, without affording any opportunity to the state to file counter affidavit, straight away quashed the disciplinary proceeding, my lord. And the states were not properly heard, my lord. We could not submit the case properly before because of no opportunity was given. Only the
on the first day itself it is allowed.
First date, the instruction was sought to be obtained, directed to obtain instruction whether the disciplinary proceeding is pending or is no already. Then thereafter, on the second date, the order was passed.
What is that apex court decision? SLP order, your flag X.
I'm unable to find it actually.
But that was a remanded matter.
Yeah.
What is this? Don't leave granted. Which is that?
So next page, sir. Next page.
Our Honorable High Court in a coordinate bench, my lord,
This is that matter where delay has been condoned.
Yes, that is that.
What do you say, brother? Why so much hurry for the learned single judge?
No, my lord. What they are submitting, my lord, this matter was filed before the tribunal, my lord. After abolition, it has been transferred to this, my lord. It was filed way back in the year 2018, my lord.
1 second. That is called the OA.
Original application.
Original application.
Yes, ma'am.
OA number?
That OA number, my lord, that is now renumbered as a WPC OA. And next, my lord. Yes, that.
Consideration.
My lord, page 13, my lord. 1-3. That is the original application, my lord. That was of the year 2018. Tribunal.
OA number?
1589. It is renumbered as a WPC within bracket OA 1589 of 2018.
2018. Then what?
It was filed in the year 2019, my lord, on 10/7.
It is filed in 2019.
18, my lord. 18.
On file from which date?
10/7/2018.
10/7/2018.
Tribunal abolished as per the notification dated 2/8/2019. After 1 year, my lord.
Administrative tribunal.
Yes, Odisha Administrative Tribunal. Abolished. 2/8/2019, my lord. By notification dated 2/8/2019.
Then a matter is to transfer to WD.
Yes, my lord. WPC within bracket OA, then the number, my lord, but original number.
For the single judgment.
My lord.
I decided now.
Decided on, my lord. That is at annexure
29/11/2022.
When was notice issued to you?
Before the tribunal, my lord. Notice was already issued.
In the petition.
My lord. It was issued. It was listed and participated, my lord.
No. This is the order, my lord, first.
Is there?
Yes.
See yourself.
Oh.
On 16/9, shall be completed and purposely initial completion as the completed in the week they do not comment or partner 16. We like it. Listen. If you look at para 8 and 9 of the Apex Court decision,
My lord.
Apex Court decision, under the Supreme Court decision,
In this case, remand order, my lord.
8 and 9. You don't have copy?
Yes, ma'am.
Yes, my lord.
Having considered the matter, my lord. This court finds that.
Can you go through that?
That the issue is required to be heard on merit. However, the court is not inclined to consider the merit at this stage, as the High Court would be a more appropriate forum for the present, but the issue of the trust out of on merit, my lord. Accordingly, the order of him set aside and the appeal is allowed. The writ appeal stands restored.
the original file and the number of the High Court. Both the parties are at liberty to make a motion before the Chief Justice of High Court of Orissa for a listing. Yes, my lord, I have gone through that.
It is that order.
Yes, my lord. By this order, it has been remanded.
Remanded.
Yes, my lord.
Should not the judge give an opportunity to them when they ask?
Well, I am the respondent. I am your respondent.
No. Writ petition. When the writ petition was taken up, should not the
they have given opportunity, my lord.
Where is that given opportunity?
No opportunity.
But on 16/9/2022,
Yes,
you were directed to
obtain instruction. Whether the disciplinary proceeding is pending or it has been completed.
Only that much.
Only that.
Prior to that, before the tribunal, more than a year, my lord.
That's all right.
And prior to that, my lord, there was a way, my lord, further way, my lord, in which the
lord filing of cases,
my lord,
inure to the benefit of either of the parties. Suppose you file a case and it's kept pending. Someday we direct you obtain instruction. Next day we say that it is dismissed because you have not obtained instruction.
No, that.
So that, my lord, is what bothering me is my lord.
What even God, very often we tell it in the open court. Biblical literature says God had given an opportunity of hearing to Adam and Eve.
My lord.
So when God gives, should not mortals give it to another mortal?
My lord,
see the result. You are now again back to square one.
What was that urgency? Whether there was a need for launching rocket?
My lord, because what happened, my lord, in this case, there was the proceeding was initiated in the 2013. 2015 inquiry report submitted with the charges are not proved. Then it was again remanded to the inquiry officer to give another report. It was the charge is not proved.
You should hear it or remand to the
No, you should send it back to a single judge, whichever jurisdiction, as Supreme Court has done it.
No, the reason being, sir, he uses a forum.
Right of appeal will be lost if we
my lord,
we are allowing this. This appeal by the state seeks to lay challenge to the learned single judge's order dated so and so, whereby the writ petition number so and so filed by the respondent employee herein has been having been allowed, the disciplinary proceedings have been set at naught. Personal. Next paragraph. Learned EGA appearing for the state vehemently argues that the learned single judge grossly erred in hastening, in showing too much haste in disposing of the matter without giving a reasonable opportunity of hearing. And therefore, the order is in gross violation of principles of natural justice. Send it back.
Lord. Ask to get the communication. What happened? What was the condition?
It was pending. It was quashed by honorable single.
And therefore you are there. The court asked you on 69/2022 to inform the status of the proceeding. What was the status?
It was pending.
pending, but what status, what state?
That was the stage at annexure.
That has not been, it was no written instruction has been.
Because the inquiry conducted, inquiry report submitted, my lord. Only order to be passed.
Process. No,
Man.
You take that please for the dispute authority that since
They have not called me. They have not called me after the second inquiry report. That is why I filed a case.
After the second so-called notice, I will publish your reply.
No, my lord. Last inquiry report was submitted in 15. Then it was remanded for resubmission of the. It was again an inquiry. Disciplinary authority, my lord. Yes, my lord. Then another.
Yes,
my lord. They submitted a. Well, yes. Nothing done. Thereafter, I approached before the tribunal, my lord. No. Thereafter, I approached the tribunal with a prayer to conclude the proceeding because we are deprived of getting my pension, promotional avenues, my lord. So, on a tribunal in first instance. The learned tribunal.
Since you have taken a specific contention that learned single judge has not given full opportunity to you, you come out with your affidavit, what all happened on which day.
Exactly.
That we call this order.
I am relying upon only this judgment of the Honorable Apex Court 95, where this state stands only taking consideration.
No, we are not there. After remand of the Supreme Court, we have to see the legality of the single judge's order. So the learned single judge's order, you say that no opportunity is given.
Yes.
So that opportunity is to be given. That fell for my lord.
And in the division bench, your lordship will grant that opportunity. We will place our case before your lordship, and your lordship will decide it on merit. No, even if there is no remand, my lord, our stand will be satisfied because we want a hearing before your lordship. We will demonstrate before your lordship.
You will be losing the appellate forum. Suppose because you decide it. So even if you remand,
but in the case which
for you also you will lose appellate forum. It goes against you. Are you confident that will be deciding in your favor?
No, I am not saying so, my lord. I am only saying that the state may be given an opportunity to place its case.
That was told to you, and now you are citing a decision.
No,
when my lord asked you that you file your affidavit.
Affidavit will be before if it is remanded before the Honorable Single Judge, my lord, we will file the affidavit to exhaustively demonstrate what happened and what is the cause of the delay, whether the state is responsible or the petitioner is responsible, my lord.
To promote the to what all happened at various schools. Every day there is something that
Yes.
Things we want to follow the but we not vaccine.
Yes, sir.
See the record we did not take some. We also will be testing.
No.
Take up that condition. Go for the Supreme Court
No. We want that state stand here before your lord. Serious grave charges are there, my lord.
Serious penalty.
Yes, madam.
The asking to secure the affidavit what is the actual officer not below the rank of the building of the department, giving the full opinion particulars as to the disciplinary proceeding of initiation to the level of the question to the level of level.
They will select
on the center for the
my name is I'm giving the praise along with me.
Filing this
the Brahma appearing after the battery is demanded by the considered by this page. That the particular can copy the operating.
Date. Yes.
It will come, my lord.
3 weeks.
3 weeks we have given.
30 July.
Item 16.
Yes, Vigilance.
Yes, sir.
This is a writ appeal against the order of the Honorable Single Judge, dismissing my writ petition and thereby denying the privilege of the benefit of stepping up to me.
Stepping up pay.
Stepping up of pay, because my junior was getting more pay than myself.
What is the reason assigned by the judge?
Reason assigned, the Honorable Single Judge refers to a footnote in the executive clarification of the government saying that since the junior person, he came to my cadre with pay protection, so I cannot claim stepping up.
You mean to say even when pay protection is granted, still the salary of the senior, pay of the senior cannot be less than
the junior. That is my concern.
Appears to be that way.
That's the sole. If you can succeed, you can succeed on that point.
Point. That's the only point.
But that pay that was protected, was ever available to you at any time?
No, pay was protected.
That person.
That other person.
Distinguished final aspect. Requires consideration. Issue notice, learned AGA Shri.
Well, there is a delay of 44 days.
He is requested to accept notice for the respondent. Next. Will condone delay, Mr. Panda. Application supported by affidavit seeks condonation of a short delay of how many days?
44 days.
44 days. Written filing the appeal. First of the logical explanation been offered for the same. First of next paragraph, in view of the above, application is favored and delay is condoned. Yes. Sir, you give copy, one set of papers to your friend also.
And you have to assist us.
Yes.
On that, whether
calculated by my lord that even if there is a pay protection, still the senior will get the same scale.
There are some such
yes, because
decisions, but there is one final aspect which my brother pointed out.
Yes,
suppose if the cadre is different, pay protection cadre itself is different, even then you will be entitled to same protection is your contention.
Yes, ma'am.
That would be discriminatory qua your cadre.
Yes, ma'am.
Because
because others will not be getting that.
Only you will be getting.
You will be getting.
Yes.
And then others will also.
Everyone should get it.
That also will arise. Because let's examine it.
Yes, ma'am.
And regarding this High Court employees, the judgment is there, but it is different. But the same.
I have got a decision of our division bench.
No, go for Supreme Court. High Court relies on that Supreme Court.
Yes, madam.
In what circumstances pay protection? Because you see the persons who are now getting employed, they are getting much more salary. 20 years back, they were getting less salary, yes, but over a period, they have accumulated. Yes,
because progressive pay scale.
Progressive pay scale.
Item 18.
This is state appeal. Challenging the order of the Honorable Single Judge where the contractual employees have been directed to be regularized, applying in a state jacket formula that Uma Devi and ML Kesari, my lord, were deviating from the observation laid down in the Uma Devi, that even if they are contractual employee, they must be brought to regular establishment, and for 10 years there is a stipulation ceiling. Here in the case where only 5 years they are in a contractual job establishment and never brought into any regular vacancy, regular post. So 5 years doesn't fit into that Uma Devi ratio below.
Even Kesari will not come in the way.
Even no, Kesari will not come.
But you appear for the employee.
Yes.
What do you say? It's only 5 years. He has to be brought up to the regular level. After 10 years.
Appointments were made pursuant to a selection.
Pursuant to selection, it was done. But the period has to be 10 years.
No, there is a circular of the government matter 6 years.
6 years?
Yes. And following that matter, the judgment was delivered. And Uma Devi matter has been recently taken.
That 6 years circular is not at all applicable because 6 years is applicable for regular employment.
Right.
6 years. Whenever there is a selection for any group C or group D, regular selection, then they will continue there as 6 years. For High Court, it is 4 years. But it's not contractual appointment. The appointment is regular.
No,
can you look at that circular? Look at that circular. Then can you look at it?
Yes.
If it is regular, and as rightly said by His Lordship, it is not exactly also contractual because you see the circular.
Let us see the circular.
And page
52 of the writ petition mirror.
The writ petition column.
And this circular manner was taken note of by this honorable court.
Kindly.
This is not circular.
No, this is a resolution.
Resolution.
Yes, it's a policy of the government. Policy regarding regular appointment of following categories of contractual group C, group D employees.
So this is another circular.
No, we are following this circular.
This circular,
yes.
Okay.
And this circular has
kindly place it.
Policy regarding regular appointment of let them place their case.
No, only the relevant person. Since you are the petitioner, so it will be easier for
contractual appointment.
Contractual appointment engagement made against contractual post created with the concurrence of Finance Department on abolition of corresponding regular post, or contractual appointments engagement made against contractual post created with the concurrence of Finance Department without abolition of corresponding regular post in the post in case of new officers, or for strengthening the existing officers' services. There are 3 categories below.
Following the recruitment.
Following the recruitment
regular post. So that I wanted to show you that following the recruitment procedure prescribed for the corresponding regular post. The principle of reservation. What is the Reservation of Vacancy Act and rules?
This policy matter has been dealt with by number of cases, including the first case of Jatin Das versus State versus Jatin Kumar Das. A large number of cases, employees matter based on this circular have been regularized.
What this you are using circular again and again?
I'm sorry, police.
There is difference between.
I'm sorry. It's a policy of regulation policy.
Which part comes to your rescue in the appeal? Which part of this resolution?
This resolution
strengthens your case.
Well, this resolution matter has been dealt with by the Honorable Single Judge Bella. Kindly sit down.
In the impugned order?
Yes, ma'am. The policy was quoted, madam. At inner page 54 of the judgment. Yes, ma'am.
Internal page 54.
Yes, of the judgment.
Go to 54. Go to 54. It is reproduced. It is reproduced.
Circular is reproduced.
Reproduced.
Yes. Where is the discussion on that?
Discussion, my lord, is after that, my lord, kindly come to page 63.
63.
Yes.
No, 7.6. It is not 63. It is 60. 60.
No, page 63. my lord. I'm taking page 60.
No, from the aforesaid resolution, it reads 7.6.
Yes, yes.
Seven point six, my lord. In our page 60, from the aforesaid resolution, it is crystal clear.
Just give us a moment.
Page 185.
That's it. The authorities at the Commercial Tax Good Service Organization were well aware of the recruitment procedure. If they are employers, have with eyes open, put the advertisement in the office notice board.
What do you say about the resolution, Mr. Panda? Learned single jet. A resolution of the government creates rights in favor of the citizens. There is one judgment of Justice Felix Frankfurter of US Supreme Court, which is quoted by Apex Court in R.D. Shetty's case. R.D. Shetty versus International Court Authority. Raman Dayaram Shetty versus International Airport Authority, where they have quoted Felix Frankfurter of US Supreme Court and said, and they have repealed the contention that the resolution is not statutory in character. In B.S. Minas versus Institute of Statistical, take up
Statistical Institute.
Statistical Institute, B.S. Minas. Take out that judgment. Where Mr. R.K. Garg contended, it's only by law of the society, government society. Bylaws do not give rise to any rights at all. Then again, Felix Frankfurter was referred to by the Supreme Court and his contention was rejected. Take out just to read that. And here is a resolution, a policy of the state, which citizens act upon. '83 Supreme Court, B.S. Minas versus Statistical Institute, which is that paragraph where B.S. Minas is referred to.
24 Supreme Court
363. They go to write to Felix Frankfurter. Yes.
Sorry,
you're not getting that.
Judgment is in front of me, but
that Frankfurter name is not there.
Why you're not opening Supreme Court SEC online? What is the difficulty?
Anyway, read that the last about 3-4 paragraphs where the contention of Mr. Garg is rejected. R.K. Garg is rejected. Identical contention of yours.
The aforesaid principle laid down by Mr. Justice Frankfurter versus Second has been accepted and applicable in India by this court in A.S. Ahluwalia versus Punjab. And in subsequent decision given in Sukhdev versus Dr. Ram, Matthew J.
Sukhdev Singh versus Bhagat Ram.
Matthew J. quoted the above record observation of Mr. Justice Frankfurter with approval.
Read what Frankfurter said now.
It is a well-settled law. It is a well-settled rule of administrative law that an executive authority must be rigorously held to the standards by which it professes its actions to be just, and it must scrupulously observe those standards on pain
of invalidation
of an act in violation of them. This rule was enunciated by Mr. Justice Frankfurter in Vitrali versus Saturn, where the learned judge said an executive agency must be rigorously held to the standards by which it professes its action to be judged. Accordingly, if dismissal from employment is based on a defined procedure, even though generous beyond the requirements that bind such agency, that procedure must be scrupulously observed. This judicially imposed rule of administrative law is now firmly established, and if I may add, rightly so.
That's what. Now the policy is acted upon. Your policy, it is issued in the name of the governor.
My lord, we cannot dispute or deviate from the policy.
Number one, where there is such a policy,
yes,
Uma Devi cannot come and block it.
Yes.
Uma Devi arose from Karnataka.
Yes.
In Uma Devi, such a policy was lacking.
Therefore,
whereas in this, such a policy is available.
But what my lord Justice Sahoo indicated, my lord, that it is for the corresponding regular principle of
that apart, you have contended the same thing in respect of 2008 resolution, and we rejected that contention in a reported judgment. We considered 2008 resolution, I remember. We rejected this contention. Where 2008 resolution, Mr. Yes, you only had appeared. Correct. Correct. You had appeared.
Mr. Mohanty from the other side was there. Mr. Mohanty was from the other side.
Correct. Mohanty was very vigorously arguing that matter. He canvassed that point also. Yes. And then we were shown 2008 resolution. Therefore, we said we cannot.
That was with reference to regulation of nurses and pharmacists.
That's what.
And my lord, so far the Uma Devi, what my friend has said, Uma Devi, my lord, has been dealt with recently by the division bench in state of Orissa versus Arun Kumar Nath. The Honorable Chief Justice has said in the division bench, when Uma Devi has been interpreted in Shripad and other cases, Jago, we cannot take a different view.
That's what.
My lord, kindly have a glance this judgment.
But even otherwise, that is one is brother. One is Uma Devi is the judgment is contrary to Uma Devi. And then next, that's the only judgment. Any other point you have?
No, resolution. As per resolution, also they are not entitled.
No, they have said here that in fact they underwent selection process.
Yes, selection process.
Correct.
But not for regular post, not for contractual post.
Even they are covered under 2013 resolution. I saw that particular paragraph in 2013 resolution. Very scrupulously I saw.
So contractual employments by the passage of time will acquire the status of regular post.
Not only that.
That is your policy.
Policy is that. Yes. If the policy of the state is that, how can you contend to the contrary to the said policy? The state is in appeal, grieving against learned single judge's order dated so and so, whereby respondent employees its petition having been favored, relief as sought for has been accorded. Kindly be seated. Question 2. First off. Next, brother. Learned AGA Mr. Panda, appearing for the appellant, state vehemently argues that relief of the kind could not have been granted by the learned single judge in view of the law declared by the Apex Court in Uma Devi, state of Karnataka versus Uma Devi. First off, he also contends that learned judge's reliance on 2013 resolution dated 17/9/2013 is unjustified. First off, in substance, with this argument, he seeks invalidation of the 2000. First off. Next paragraph. A learned counsel representing the employee for contra submits contends that the ratio of Uma Devi would be miles away from the case of his client, in as much as rights have accrued to the employees of the kind under the state policy as promulgated under the 2013 resolution. First off, he also notifies to the court that it is not that it is the case of the respondent employee was a backdoor entry in the strict sense, in as much as there was selection procedurally undertaken under the extant provisions. Then, first off, so contending, he seeks dismissal of the writ of inexpert. Having heard the learned counsel for the parties and having perused the appeal papers, were broadly in agreement with the submission of learned counsel representing the employee, in as much as learned single judge has rightly considered the state policy as promulgated under the 2013 resolution. First off, next paragraph. The vehement submission of learned counsel Panda that the resolution has no place to play in the matter is bit difficult to countenance. First off, the Apex Court in B.S. Minas versus Statistical Institute, following Apex Court decision of Justice Felix Frankfurter, has observed as under. First off, the above part, where the state policy provides for certain rights, regardless of statutory support, the violation of such a policy gives a cause of action, and compliance with the policy silences the causes otherwise accruing in the matter. First of all, the decision of Uma Devi cannot be chanted like mantra to defeat rights granted by the state in favor of the citizens under its policy. First of all, policy of the kind was apparently absent in Uma Devi, and that makes all the difference to the invocation of the ratio laid down therein. First of all, next paragraph. In the above circumstances, appeal being devoid of merits is liable to be rejected, and accordingly it is, courts having been made easy. Yes. Took that B.S. Minas 83 Supreme Court, 84 Supreme Court. Is he our court researcher? Yes, researcher. That copy of the, where is the copy? Give that to 582 and show that Minas judgment, that Frankfurter's judgment.
Last three paragraphs.
Okay.
Last three paragraphs of that.
Okay.
Item 19.
Last three paragraphs.
Maybe.
Yes.
Say appeal against the order of single judge, where the honorable single judge has confirmed the termination passed by the collector.
Termination from service?
Yes, ma'am.
Termination was on what grounds?
When the petitioner was continuing as a additional assistant PD that day, he was deputed to a meeting held in Bhubaneswar on 9/12/2022.
For that we are terminated?
No, Malik. In this meeting, there is an allegation. After 2 days meeting, they come back and continue the service. When we continue service in February 2023, a letter has come from the collector terminating service from 22, that is 1 day before, on the allegation that the director made the allegation when you are residing in the hostel, there is an allegation that you have knocked the door of a inmates where the ladies were residing. That is the allegation. But
it's a serious allegation.
But there is no the allegation, who has made the allegation and what is the allegation, that is not there.
Gandhi Medical College.
Sir?
That the boys entering ladies hostel at night.
No, not entering. This is a common hostel. All the
so still worse.
With one hostel, they are both there. No, they are reading. They are staying in one room.
There is a direct decision that in this kind of allegation, what would be the limits of principle of natural justice?
I don't know. This is my response. So only the allegation that is
also that decision. That suppose a unknown person goes and knocks the door of a lady in a hostel, she will open take a photograph, to ask for the Aadhaar card, then we will lodge a complaint.
That is the.
So that the Supreme Court has analyzed. It's not my version or view.
But these allegations are something different from this. In a common hostel.
Where is that allegation part? Which page? Which page?
The order of the collector. Annexure 4, page 18 minutes.
CCTV footage or what?
No.
What was the?
In one hostel, both the ladies and the gents are staying.
Kindly respond to the court, sir. What was the evidence to Delhi?
There is no evidence at all. Only that the allegation. There is no evidence. There is no footage. No, the person concerned who was alleged. There is nothing else.
No, we are asking you.
Only I'm coming to page 18, the collector's order. But my lord says, put the question, that is annexure 4, page 18. There is 23 to 2015. There is.
Where is your written explanation?
My lord, without giving a written explanation, that has been terminated.
No. Kindly read it.
Sir, actually, you are not getting
it. See, the order says you have confessed to the guilt.
That the confession was that I have mistaken. If that is not that is mistaken because
Where is that?
That was not in the record. They have not filed. Subsequently, they have placed before the at the time of hearing before the single. But that was neither in the counter statement.
Why can't you hear judges first?
No, madam. That has been filed before the. That is filed at the time of hearing. That was filed at the.
Sir, if you don't listen, then you cannot follow. Or else, if you know what you are saying, then you can say that.
Two monologues do not make a dialogue.
No.
Said Osho.
Yes.
Therefore, we should be able to understand your version.
Sir.
You should be gracious to understand our version.
Sir.
We are asking a question to you. Kindly come to the office order dated 23 February 2015.
Yes, ma'am.
Read second paragraph, one line.
Sir. Whereas Sri Mahakul has confessed to his misdemeanors in his written explanation.
We are asking you, where is your written explanation?
Yes, madam. That I am submitting, that written explanation neither filed during the filing of counter nor nothing else, but at the time of hearing, there has been documents was placed before this honorable single judge. That was not in the record. That was not given to me. Yes, ma'am.
Do you dispute?
No, I am not disputing.
You don't tell this. Then confession is there in the question.
That is this confession. What I learned from this confession order, that they have stated that the knock has been made by mistake. When I am residing in the nearby room, there was a knock by mistake to that.
At what time it was?
At 8 p.m.
8 p.m. 8 p.m. Where is his room?
So the nearby room in one hostel. In a common hostel, they are staying in another room. They are staying in another room.
Another room in the same hostel?
Same hostel. In the common hostel. Common hostel they were staying.
This one. Counter this one.
The counter they have stated that.
Can you please stop for a moment or so?
1 second. We'll just come back to you. We'll come back.
If you are not answering, you have to do it.
No, sir. Okay.
In fact, he had opened the window also. Not only just knocking at the door. Knocking at the door. At times, fate knocks at our door. We understand that.
There is
Fate does not open the windows as such.
Knock the door.
No, you have said, when opening one window, wherefrom they saw, the lady saw him. The lady inmates saw him from the window. It cannot happen unless you are struck.
The allegation was not the
problem is that you went to a state institute, SIRT in Bhubaneswar.
Yes.
The inmates are unknown to you. It's not your hostel, as you are saying. That is also another problem.
Yes.
The only thing you can argue now to assist you, is it stigmatic for your future engagement? Have they put any kind? Because it's a 1 year contractual engagement.
No, that is, I have continued from 2011. And that is a persistent.
You can't change the facts by filing a writ or writ appeal. It was a 1 year contractual appointment engaged from renewed from time to time.
Yes, ma'am.
You have not come here for regularization, or you have your prayer is for regularization. No. You are challenging your removal after that alleged incident.
Yes, ma'am.
So now, suppose future engagement, is it a bar for your future engagement in any manner?
We'll say that it will not be a bar.
Yes,
I mean, they have to concede that to that extent.
Yes, yeah. Yes,
future.
First point out that which party is stigmatic. It is a simpliciter disengagement. So you are inviting observation of the court to discuss all these things, which will be casting stigma on your client. That you must realize what you are unwittingly what you are doing. Yes. If they don't cast, why you should invite them not to cast or to cast?
If we remove stigma, then it becomes a ground for him to challenges. The order is stigmatic.
Removal order?
It's
this is the order.
No, read petition, sir.
Yes, page. Read petition.
So.
Relevant portion, page 56. Page 56.
He says that very innocently he went and knocked at the doors of that ladies, and very innocently he opened the windows. Well, he did not break open the doors. That's the only grace he has shown to the ladies.
My lord, in the first writ petition, he was afforded an opportunity to make a representation. He made a representation. That representation, along with personal hearing, everything was afforded.
No, personal hearing, collector rejected.
Why personal hearing in matters like this? When you are confessed,
personal hearing.
That's all right.
And my lord,
this is litigation history.
Yes, that was WP number.
That was WP number, my lord, 3812 of 2000.
That order is annexed to 5.
We are asking the WP
12 of
3812 of. Nobody gives the number.
3812 2015.
Yes, ma'am.
Disposed of on 4th of March 2015.
Yes, 4th of March of 2015.
381215.
We all agree, sir.
What learned single judge said? Give him opportunity.
No, you approach the collector. You approach the collector. File a representation before the collector. Collector will consider.
Representation was given.
The representation was given for the collector. Collector rejected it.
Yes. Against that, you went before the single judge.
Sir, yes. Yes. Against the rejection order.
You gave representation on which date? Representation dated?
Dated.
Nobody makes notes here. No notes.
When it is quoted as a petition, page 5. Petition page 5 colon.
That's all. Page 20 also.
ते बड़ा करंतु नहीं दूसरी वाली ये छोटा करंतु बस
So it's a negative condition.
Your representation is not available.
No, not available. Not available.
Annexure 5, sir, the order is there.
First go.
381215. That was disposed of on 4/3/2015. Yes, there are.
Representation annexure at page 4.
No.
Yes.
No, that representation is not annexed, sir.
What is the order disposing at? What is the order?
That is annexure 5. The order disposing by the collector, that is annexure 5.
In the read.
No.
Then what did you challenge?
I am challenging the second repeat order.
The second repetition annexure, collector's order.
The collector's annexure 5, sir. Page starts from page 19. The page 21.
There is no. The High Court's order.
Yes.
Which is the order passed by the collector.
Yes, sir, that is. Starts from page 19. 21, your lordship shall look to page 21. Starts from 21. Peruse the representation of the petition received from the superintendent of the High Court. That is such and such.
The reading in the read petition.
Yes, ma'am.
11796.
No, I am reading the read appeal, ma'am.
How you did not challenge that in the read petition?
No, I have challenged the read application.
Which page is the read?
The read petition. Sir.
After the privacy changes, Buddha Swami, the element of privacy of men and women
Yes.
The right to privacy based on complaint did not teaching as fast as it's
Your lordships.
the character of the
Yes, sir, your lordships are absolutely right. But here the case is that in a common hostel, I am residing. Inadvertently, by mistake, I have knocked the door. I am residing in the nearby room. But I have not entered the room. I have nothing else. There is no allegation there, madam. No allegation there, madam. Only the. No, there is no allegation of. There is no allegation of opening. Only knocking, madam. There is no allegation of.
That's not.
You wanted them not to open. That is how you knock. You knock at a door with what intention?
You open the windows.
Only
saw him the windows.
Sir, but that is what as per my permission, since I am residing in one room, more than 2-3 persons are there. Since I am residing in one room, nearby room, I knocked keeping in mind that that is my room. When I knocked the door, when I knocked the door, some lady no, my lord, that is.
Kindly listen.
Yes.
Where you have stated that in your explanation or you content in your petition only.
The explanation I have given that only by mistake I have knocked. That is my explanation. Only by mistake I have knocked.
No. You are not saying anything about opening of the window. You did not open the ventilator. You did not.
No, I have not opened the window. When I knocked the lady inmates, they have opened. Who have knocked? I have not opened.
That is not the case. This is a very specific case against you are. You will not take the rules. Untimely. But you opened the doors of the window. Window pans were open. Then lady saw you.
I have not opened, man. I have not opened.
No, you take it.
He has confessed. He has confessed his guilt. He has confessed his guilt.
I have confessed. I have by mistake I have knocked. That is a confession.
Mistake we can understand. Suppose somebody is in a condition, the time is like that, very etc. They can understand. Very the justification in the video itself. Maybe you would have jumped into the room if there was the video transparent.
No. When I knocked, the inmates have not opened it. Window.
Right.
I don't know why there is a stigma in my.
Stigma will that is that. Or if you can make observation. But now if you treat your own attention, our order will be apparently stigmatized. Your termination is not simplicity. It is on a wide allegation. Okay. Instead, what we can say, we will show you some concession. Provided you think of, we give liberty to withdraw the petition, saying that the order is not stigmatized. But if you permit us to write, then we have to write some.
Permit to withdraw.
Challenge is to a rugged single judge's order whereby opponents are looking in the same petition, they have challenged the order of collector of district magistrate. There are 15/5/2015, whereby the 1916, whereby in fact the termination from service happens on a particular conduct. First, it hardly needs to be stated that a matter was considered pursuant to a direction of this single judge of this court, in petitioners using A was to move to 2015. This court of first. Next paragraph. Learned counsel appeal from the appellant and it was vociferously argued under for time. Now, since leave of the court to withdraw the petition itself. Retribution itself. Otherwise, this will remain.
Retribution are disposed of already.
Yes, sir. That was one plus. Whichever way, we seeks leave of the court to withdraw the subject to the condition that the order in question may not be treated. Into order of termination may not be treated as statement. Which employment prospects are not available.
Sir.
Yes, petition judgment stands at you.
It's the matter for you. The serious rights. Restitution better than that.
What do you do? You have no permission from the right counsel. Do not let us the way to it. This observation will say, all right, no. This observation will say.
Yes.
Mr. Panda, can we say that Panda graciously agreed with this state concept? Police. Ordered accordingly, the rate of release this.
Item 20.
21 of this state appeal. Well, yes.
where there was a allegation of malpractice to enter into the service. For that, the appointment was asked, my lord.
What was the malpractice in examination?
Malpractice in examination. Cricket certificate. Not secret.
D.
20 million. Yes, my lord. Delay condonation not shield, my lord.
It is better now. This 76 number is also dangerous.
Dangerous, very dangerous.
Now it is. Wait, someone.
My lord, let notice go.
Issue.
Yes. Within 7 days.
Right on the.
Yeah, 7 days.
Lordship is asking whether you are also agreeing, so you can proceed.
Sir, I'm sorry.
Now it is some we got in our hands. Yeah.
Only I am writing a memo to the.
This
Item 21.
21, may I please? The Union of India has filed this writ appeal against the order passed by Honorable Single Judgment, order dated 21/6/2024. There is a delay, no notice has been issued. First time it has been listed, delay of 79 days. So far the merit 79 days. So far my calculation is concerned. Union of India. The case, my lord, here the petitioner has filed the writ application with a prayer for enhancing his age of superannuation from 62 to 65 years, since he was working as a professor in physical education in Sanskrit University. Our case is that, my lord, which has been allowed, though he has been retired from the service since 2015, but Honorable Single Judge directed for 50% allowed the writ application with 50% allowance within period of 2 months, my lord.
The direction is enhancement of the age or entry order?
No, dispose of post enhancement after retirement.
Was there any entry order?
There is no entry order, only subject to result of writ application. At the
Supreme Court say age of retirement for UGC pay scale holder is
65 years for teaching staffs. He is a non-teaching staff.
Physical education is not
non-teaching staff, because at Sanskrit there is no course at all for physical education. Only the post is formal to.
Teacher means
he was.
Will not be teacher at all.
He is only he is a teacher, man. He is a teacher, but he is taking outdoor classes only, not indoor teaching classes, man. Now here. Here, my lord, so far our course is concerned, there is no physical teaching courses, man, because Sanskrit University.
We are asking you to request you to assist.
The teacher post that teacher post definition recently I don't have my.
Teacher is defined under the CPC guidelines. Textbook say. The physical education teachers are also teachers.
And they are teachers, madam. They are teachers. But our institutes.
I don't apply to regular teachers.
Now, here what happened, madam? He was initially appointed as a physical education instructor.
He's also teacher in the.
Yes, he is a teacher and he has been promoted to the deputy director and assistant professor, subsequently professor, madam. And he is getting UGC scale of pay. He is a teacher. Your Lordship, I have annexed the document which clearly says the UGC guidelines clearly says only one single line, Your Lordship kindly say. Page 53 of the writ appeal, madam. Madam. Appeal memo, madam.
Yeah.
Age of superannuation, clause number F, my lord. In order to meet the situation arising out of shortage of teachers in university and other teaching institutions and the consequent vacant position therein, the age of superannuation for teachers in central educational institution has already been enhanced for 65 years by Department of Higher Education letter number so and so dated 23/3/2007 for those involved in classroom teaching in order to attract eligible person to the teaching career and to retain teachers in service for a longer period. So he has not taken classroom teaching. That is the only point.
Surya Namaskar, Chandra Namaskar, Nakshatra Namaskar, these are done within the room, classroom itself. Are they not there? Where have you stated that? You insert the in for the read for the F3.
F3.
Whereas the announcement of information.
Whereas the announcement of the age of superannuation for teachers engaged in classroom teaching is intended to attract eligible persons to a career in teaching and to meet the shortage of teachers by retaining teachers in service for a longer period, and whereas there is no shortage in the category of librarians and director of physical education, the increase in the age of superannuation from the present 62 years shall not be available to the categories of librarians and director of physical education. So he is his initial post is director of physical education.
Initial post.
Initial post is instructor. He has been promoted to director. Original post is director of physical education.
Issue emergent notice. Returnable within 2 weeks. Requisites to be furnished immediately.
I filed an interim application.
But application you can't delay.
He had already 65 years attend.
2 months time given, contempt application he has filed.
It's moved now. Contempt matter is moved.
2 months. One of the thing is the director to pay the 50% allowance within 2 months.
Let him be served without condoning delay. We will not have power to do it except in cases of matrimonial matters.
Yes. Oblige.
Item 23 to chapter.
Whatever, we are coming back, sir. We are not leaving. You can inform any of your colleagues. Yes, call the next on the list.
EC case, essential commodity case, can deny or
suppress judgment, I said.
My lord, that in fact, despite my best effort, I couldn't locate. I may be pardoned for that. My lord, I couldn't. My lord, I have researchers also who are very expert in that field, and I have all those SCC and Manupatra everything. But somehow, my lord, maybe my line of
2016, 17, there is a
17. That is the theme I took because your lordship had been pleased to observe that it is around 2017.
16 or 17
and around. I tried to search for, but unfortunately this time I couldn't.
Read that section 6 of the Act.
Yes, section 6.
5 and 6.
Yes, madam.
Read. Very essential. Somebody says.
Section 5 and 6 says
you are for. You are assisting him.
5 and 6, if your lordship.
There is one judgment which says, in the event, because section itself reads that way, long ago, 10, 15 years ago, I read that. Give that.
When it says.
Commodities Act. There is one section where he is acquitted in the criminal case. What are the consequences are mentioned in one section?
Man, that is exactly not the case so far as Essential Commodity Act is concerned. It speaks about confiscation. May I just point out one thing? There are three aspects. One, a criminal case has been instituted against him for breach of trust and other things because he delivered 5 trucks out of 14 trucks and 9 trucks 4 days after an inquiry of different brand, not the brand that was loaded in the truck and in different truck also. So that is one criminal case. Now the criminal case was intimated to the collector who initiates a confiscation proceeding under the EC Act and also the PDS control order that is framed in terms of the EC Act, Section 3 of the EC Act.
Yeah.
Now this has been deemed
essential commodity.
As your Lordship was pleased to observe, Section 6 says,
Section 6 says,
with regard to the overriding effect, notwithstanding inconsistency with any other enactment.
It was a very suppressed judgment. 2016 or 17 judgment.
I'm still trying my best. I will try to get it also. But here the point that I had raised for your Lordship's kind consideration is, despite dropping of the EC case by virtue of the observation of reasonable court in another writ petition where the appellant was not a party, where the conditions stipulated in the agreement will have force and will have a right to ballot because, your Lordship, this is not a proceeding under the OPDR Act. Had it been a proceeding under the OPDR Act, things should have been different because that is the initiation by us. And if it is terminated, then that will deprive us from again claiming anything. But here, EC case is completely in a separate domain and it cannot take away the effect of the conditions in the agreement itself, which says that, yes, we have a right of recovery. Forfeiting the security deposit and other.
That recovery proceeding was subject matter of any proceeding before this?
There was no recovery proceeding at all. A petition was filed for this noble court, praying that his dues should be released. A direction was issued for consideration of his reprehension. Reprehension was considered and rejected. He doesn't challenge rejection.
And also not challenged.
Rejection order not challenged. Again, a fresh petition is filed, enclosing that rejection order, praying for release of the bills and security deposit. We took a stand in terms of the agreement. We have a right of forfeiture. So therefore, he is not entitled to. But the impugned judgment has been passed saying that it should be released and that is how the appeal has been filed.
Yes. So there is prima facie breach of trust because he did not carry the goods. He misused the goods. So let us issue notice and then we will know what the case of the other side is. We'll issue notice. Issue emergent notice. Returnable within 2 weeks. First off. Requisite should be furnished within 3 working days.
So far, respondent number 1 is concerned. Since he appeared on her own without a caveat, I have given a copy already.
You have served a copy?
Yes, ma'am. It has been given. Your Lordship may record that.
You come up tomorrow. You come up tomorrow then. Registry to show her report.
Her name is there. Her name is there.
It's here.
Your Lordship may place it for hearing after issuing notice.
Even after caveat, once again we have to issue notice.
No, there is no caveat.
No caveat.
He appeared, I have given a copy. There is no caveat. That is the distinction.
Appellant to serve a copy of the petition along with all the documents on the learned counsel who represented the respondent in the court before the learned.
That has been given, madam.
The copy is given to you.
Yes.
We'll fix some date.
Yes.
All right. Now notice has been issued. Okay.
And the other state functionaries' copy is there because they get it automatically through online.
Extra copy if they want.
Extra copy, your Lordship has made a system that they will get it downloaded.
They have to email.
Only submission is that they are being the corporation, my lord. I am the blacklisted and is now in the abject penury, my lord. This is the amount which they have not withheld for so long.
So let us fix a day. We'll hear the matter once for all and complete it. State for Deputy Commissioner who appears. Who respond, official respondents.
Brain will appear.
Item 6, item 6.
Item 6, yes. Panda, AGA, who appears.
Respondent 3.
Respondent number 3, who is an official respondent. Okay, call this matter in the third week of August 2025. Third week. That's it.
May I pray my Lord, little earlier? On my
calendar is heavily loaded.
They have not taken any step to
Second
list
week
it.
of.
My Lord.
Only one thing I pray. Lordship remembers in the other case where there is a contempt. Here also there is a contempt.
There is a
Lordship
contempt.
Protect. Yes.
Till they precipitate the contempt matter.
No, yes. My Lord, because on contempt, giving us late appeal number. They never list it.
It is agreed before us that contempt proceedings shall not be precipitated.
That is 7591 of 2024.
In
CONTC number 7591 of 2024.
Shall not be precipitated.
Okay. I'm so grateful. Ajay.
Item 22.
With the observation that where the direction has been given to regularize the appointments of the contractual employees at page 99 of the income judgment, running page 99, para 13.3.
13.3.
13.3. And in the last order also, it has been reflected by the Honorable Court while issuing notice, condoning the delay. That is, my Lord.
In both the matters for the respondent, the senior counsel is appearing.
In both matters, I am appearing. The first matter, state has challenged. The Honorable Single Judge has passed the judgment in my favor totally, but last order, last direction was to consider. That is what I am challenging the second one.
He should have straightway granted the relief itself.
Relief.
Easy work.
That is exactly.
What was the relief you had sought?
Relief is these petitioners by way of a selection, pursuant to an advertisement, offered their candidatures, eligibility criteria, they have satisfied. A selection committee was constituted. They were selected, appointed in 2002. Then thereafter, after 2013 rule came into force, they applied the 13 rule, and they paid also the remuneration. And they continued thereafter till today, they are continuing. Now the question is sanction post has been sanctioned. Now the whole question is for regulations. If your Lordship will allow me, I'll show 2-3 documents and the finding of the Honorable Single Judge.
But not today may not be possible to us. We'll fix some date. This is 2025 matter. These are very old matters also.
The whole difficulties, identical matters, Your Lordship, just now also hearing Your Lordship of disposal. Item 18. Exactly.
Identical matter.
Not that, ratio. 13 rule, Your Lordship interpreted item number 18.
2000 resolution 2000.
Yes, it's same time.
This is also same resolution.
This same resolution, yes.
That was a September resolution.
Yes. My Lord Friend can say he's very also true.
The resolution is September 17, 13.
Just looking to we will finalize that draft, that judgment which we have dictated today. Then you can make use of that. We also can make use of that.
Yes.
In the first week of September. Yes.
September. But no, Your Lordship is already disposing of
second week of August. Second week of August. Yes.
If that will be covered by case.
Let us see. We just because we are ready to frame that judgment, we have just given the dictation in the open court. Something needs to be done there. That's the reason.
Can I be permitted to in the first week of August so that at least I can?
But second week, only 1 week. Not even calendar page will be changed. First week of August. First week of August. Okay.
Item 25.
Yes, sir.
26 adjourned.
Withdraw. 26 withdraw.
My lord. The petitioner read before this honorable court seeking a direction, my lord, to the state opposite party, the grade pay, my lord, 5,400 instead of 4,600, that grade pay, that which the period
that corresponds to which pay scale?
Pay scale, my lord. Pay scale, my lord, that is the page 12 of my prayer, my lord, can have a glance. Further, would you please to direct the opposite parties to allow the petition to draw his pay scale 9,300, 38,800 with grade pay 5,400 instead of 9,300 and 34,000 with grade pay of 4,600.
Who is your opponent?
22/12/2010 as per the 6th Pay Commission report to answer 8. The fact remains.
Who is your opponent?
My lord.
Your friend. Who is your friend opposing you?
Opposing that the state is the opposite party only.
State.
That is the my respect to submission before my lord. Prior to then I will give the brief fact of the case.
Ready in the matter, brother?
That is the very simple question, my lord. That is the my lord, in the opening of the family court in Justice of Bhubaneswar, my lord, in Khurda, my lord, Annex 2. That is the 12 post has been, as per the schedule, family court has been created. That is the serious Tadar, one of the post in serial number 2. My lord, page 15, Annex 2 of my brief, my lord.
Page 15, Annex 2.
Annex 2. Letter dated 17/5/2010, Government of Orissa Law Department. That is serious other post will be, that is the remark column to be filled up by promotion, my lord. Thereafter, my lord.
One second. Let us see that.
Yes, madam.
I'm directly to the sanction of government.
Can I ask you something?
Yes, ma'am.
Who has rejected your claim?
Nobody rejected, but it is recommended to the government, but it is pending. My lord, can have a glance. My lord, put the vital question. That is Annex 4, my lord, can have a glance. That is the Judge of Family Court dated 29/1/2011 recommended to the government to consider and fix the scale.
Your prayer is for consideration, and because we cannot take a decision as far as fixation of pay is concerned.
Yes, my lord, direction that.
Yes, they take a direction already.
Already
we will direct them to take. They have They have not taken decision.
Yes, no, they have not taken decision.
Why you have not taken decision?
No, this is not entitled value.
That you tell him by writing.
Let him move.
Yes,
and give the reasons.
Give the reason, yes. Unless of course. So that's why I am before my lordship.
Where is your representation?
Representation I have not given, my lord, that is after retirement, my lord, that they have not said so. And in page 20, Annex 5, that is the officiating page is there. But as per City Commission report.
All right.
This is why the recommendation is 29/1/2011.
Yes, my lord. My lord, sir, on that day, put such question.
No. For past 14 years, it is pending.
It is pending. Till now, they have not given anything.
Limited.
So that's why limited agreements, man.
We will ask him to pass order tomorrow, a day after tomorrow, and we will post this matter. Otherwise, again.
Yes, on Tuesday, my lord, put. That is the matter. We will give the details.
How many years you need to pass orders on their recommendation? You don't want to look into grievance of the citizen at all?
Yes, ma'am.
You are saying yes to my question that you are not going to look into.
Definitely will look into the matter of grievance of the
Article 350 of the Constitution. Though it is language specific, it says where there are judgments under 350, where a grievance is raised by any citizen, that should be addressed by the government.
He has not filed any representative before the competent authority.
The writ petition is before you now.
Yes, madam.
That you treat as your representation until you are claiming to pass order.
Yes, madam.
That we were, which students of law, we were told there should be always representation demand before seeking mandamus is loosened to a great extent. The petition is with you. And with that, you can tell your client, see, the judges are angry, pass order on that.
So why according to use the counter?
Amen.
They deny your pay?
They deny them. I'm officiating in the scale of pay. They are admitting in counter.
Will it be, I mean, because that call you have to take or your client has to take.
My lord,
suppose they deny now in the counter. It has to be admitted before.
They are admitting in counter. But now they are saying in a second, when it is adjudicated once before my lordship is also a member, when the Justice Mahapatra is there, my lordship is there. They said that the additional counter, they are saying now you are officiating but not entitled. Now in Orissa Service Code, my lord, is very clear that officiating scale of pay is entitlement and state government should have to fix. Then as per rule, I am entitled.
One second. Which is that rule which you are banking upon now?
Making appointment and appointment, they have given appointment as per the district subordinate court rule, my lord.
No.
In a family court rule, my lord, it is very clear, my lord. In the family court rule, the petitioner is entitled to get. My lord, kindly have a glance of family court rule. That is the 4B.
Please read. We don't.
And my lord, I am placing. My lord, I am permitted to place.
Yeah.
The Family Court of Orissa Rule 1990. My lord, the number of categories of the other employees of the Family Court, the number of the categories of other employees of the Family Court shall be as specified in the schedule appended to these rules. The condition of service, my lord, I am placing. The condition of service of the employees shall be that as applicable to their counterparts under the Orissa District and Subordinate Court Minister Rule, Method of Recruitment and Condition of Service Rule 1969. My lord, as per the rule, I am at par, and the other person, if they are entitled, I am entitled. So that's why even
other persons who are like you, they are getting what pay scale?
That's that I have in my prayer, my lord.
To improve upon this lack of understanding of the whole thing, can you present a tabular form so that you can exchange with your learned colleague? Because we cannot say that what exactly you are getting at which stage and now what you should get.
Now, my lord, the present scenario that I have been retired from service. So but my fixation, my scale of pay, that is whatever I am officiating the period, that they have not considered at all. So that's why I am praying before my Lord that if the state government, as per the recommendation of the family court judge, will consider and pass a reasonable order. At present, my lordship what suggested that the matter will be clear.
Let him take instruction. You take instruction.
Yes, Tuesday, my lord, that can be.
Today is Tuesday. Next Tuesday.
Next week, anytime my lordship pleases.
Next Tuesday.
You bring what you would have got. If that pay scale was granted to you.
Yes.
Table.
Yes, table.
In a tabular form, you have to bring.
Yes.
The counter in the additional affidavit file on behalf of the.
No, now at least to that extent he has taken a step back. He says that if you consider and pass an order, then he will whether he will challenge that or it's up to him. But that instruction you have to give us that you pass an order within a stipulated time, maybe within a week.
Yes.
Within 1 week.
Last affidavit we have filed, my lord, that page 3, the table given by the opposite party 190.
He may utilize that. He may utilize that table, let him come back with it because he is the claimant. You can't trust upon him that you accept this table.
My lord, in page 3 of their counter, the my lord, I am permitted to place that apart from there, they are the state meeting.
On the basis of that, you prepare your table.
Yes.
Okay. Then we will hear you on next.
Yes, my lord. Apart from this, petitioner was working as a Sisarstadar, family court, by officiating, but not appointed. So that's why this is their account.
Lordship is dictated.
Yes, my lord.
On consent of the Lord Counsel for the parties, the matter is adjourned to
Tuesday or any day, my lordship, to your convenience.
15th of July 15th of July 2025. On the said date, the learned counsel for the petitioner shall file a comparative table indicating the scale of pay he claims as against the scale of pay he has received.
Yes.
The learned counsel, the learned additional standing counsel refers to the table.
Yes.
Annexed in the additional affidavit.
Additional affidavit 7/4/2025, madam.
7/4/2025. The same shall be considered on the next date.
Yeah, problem.
Item 28.
They say he was not promoted, you know. There's no right of lien to the board unless lien is there.
Yes, Lordship. Mr. Acharya Lordship. I'm associate of.
Sir, I'm appearing on behalf of my seniors for opposite party number 2 and 3. Because I'm seeking a short adjournment, man.
You make prayer to your senior friend. If he agrees, so we'll also agree. Which date you want?
Possibly tomorrow, if it is possible.
So we have our calendar is tightly put to the schedule now.
If it is possible, my lord, next week.
Next week?
Next week.
Just take a chance, but we do not know.
Because my clients, the retired persons they have not got any returnal benefits.
They have not got any returnal benefits?
Returnal benefits.
11th.
11th. For October, not 10th, 11th.
18th.
Sir,
18th.
18 July.
Yes.
My lord, may I please anything? In that first matter, item number 29, my lord, there's an interim order, my lord.
In my case, also interim order is there.
Yeah. In all cases, wherever interim order to continue till next date of hearing.
Item 31.
Much was.
31. Not doing.
You have received now. We'll call this matter in first week of September.
First week of
September.
No, my lord.
Last week of August.
Your lordship is being asked going back.
Because other matters are posted now.
That's right, but
older matters. This is 22 matters.
Possible. Let me go through it.
That's what. You go through it leisurely. So we will take up the older matters. Now, if we post it next week, not possible.
No, I understand the code. I know how. Well, I will submit now only because your lordship would like to have a look at it. I must. Your lordship last occasion asked for the DPC
A promotion order.
And the promotional order. That is possibly what they have filed.
Date of plus previous order है 18/12 है ना सेटा कंफर्म कर रहे हैं डीपीसी कितने पेज गोलू डीपीसी the first page.
So conductor, you have held before this court is having a copy and in the registry, or you are handing it over?
Registry, my lord. What is the essence of the dispute?
Essence of dispute, if you lordship would recall, I retire on 31st December of a particular year, 2029 to be precise, my lord. Though the DPC was held, I have been officiating since 1/7/2020 in the said promotion.
You retired on 31?
No, I am likely to retire. I am there in service.
You are still in service.
So it is a missing out the last increment, that is the subject matter.
One increment is missing.
I am likely to miss out unless your lordship intervene in it. Reason is like this.
No, that 2812. 2812 is the 2512 or 2812? That date.
1812 is the date of DPC. Results published on 2212. Whereas I was called upon.
Just give us a moment.
Date check to do.
Then when it was notified, when the vacancy, when the promotion was notified.
Promotion was notified that your lordship would find.
1812 DPC head.
DPC head. 22nd December 2020, they have filed a document, my lord.
1812 or 2020?
1812 is the DPC.
1812 or 20? 2020.
2002.
The promotion notification, the 2nd January 2021.
And the
DPC was held.
My lord.
That actually DPC recommended your case for promotion.
Yes, your lordship. That
to the post of?
My lord?
To the post of which post?
It is Superintendent Level 1 Typist Cadre 1 post. That is a page 9 of that brief that he has submitted now. If your lordship is holding
Level 1. From?
Level 2, my lord. Superintendent level 2 to superintendent level 1.
Level 1.
Typist cadre.
With that promotion was granted to you on which date?
That is, my lord, last page, last part 1 page at the end of this.
We're asking the date.
22nd December 2020.
No, they are saying 2nd January.
My lord, I am coming to that. Notification is there, my lord, order is there.
124.
21. Look like 4, but it is 21.
That paper he has filed the result.
So promotion is given to you on 2nd day of January 2021.
That was given to us.
Is it with the retrospective effect or with prospective effect?
Now it is prospective, so I am not going to retrospective affair, my lord.
Now, what should happen because of this promotion?
Because that I saw your lordship, that your document, your lordship possibly missed out. My kindly seen a document dated 22 December 2020. That they have also filed.
22 December 22.
20, my lord.
Result,
sir.
No, that is how we require this. So now, after the question from my lord is after 2nd January 2021, what you should get and what you could have, or what you could have got and what you have not got.
I retire on 31st December 2029.
No.
Yes.
Starting with this, suppose on 2nd January.
You were right, 7A.
On 2nd January 2021.
On 2/1/2021.
My lord?
You were right to receive emolument, increment, whatever. That is in the post of which post?
This superintendent level 2?
Level 1 or
level 1? Level 1.
Level 1.
Level 1.
Level 1, your rights will arise with effect from 2/1/2021.
2/1/2022. I joined on 4/1. As per their instruction, I joined on 4/1.
So 2 days.
My lord?
So only 2 days difference.
Had it been on 2nd, my lord, by virtue of government, sir.
2nd of what, sir?
2nd of January, by virtue of government notification, it would have been taken as if I am getting advantage of the 20. I am not getting 2021, my lord, that increment for the particular year.
To get that increment, what is the condition?
I should be promoted on 22nd December.
Yes, you are promoted 22nd December.
Yes,
how can that happen?
That is the results publication.
No.
Gazette publication.
We cannot antedate the result publication.
Your promotion is one of the 3 known modes of appointment.
Yes, your lordship.
Do you agree?
Yes.
So appointment happens when the DPC recommends. That is not the date. On the recommendation, order is passed by the employer saying that we agree with the recommendation of DPC, therefore we grant you the promotion. Accordingly, they have granted promotion to you.
Yes, your lordship. That is how, as it stands now. Now, in order to substantiate my case, your lordship, last occasion I was placing.
Now, right to increment arises under which law? So many pages are not necessary at all. Under which rule your right to our increment arises? Show that.
I am not equipped with the rule today.
Yes, read.
I am not equipped with the rule today, and certain decisions in this regard. Our High Court has passed order also. Saying that I am entitled to be promoted not only from the 22nd, but also from the retrospective date, that is from when I am officiating, that is on 1st of July 2020.
1st of July 2020.
This post
you were kept in charge of that post.
That post.
You were kept with effect from which date?
30th/6/2020 itself. That your lordship would find at page 10 of my writ petition.
That was on an independent charge basis.
My lord?
In charge basis.
In charge, direct to hand. I am pressing page 10, your lordship, of my writ petition. Pursuant to the district office such and such, communicated by such and such, Sri Chimachra Paikra, myself, district level such and such, here we relieved from the duties. My predecessor retires on 30th June 2020.
Correct.
Further, Sri Paikra is directed to hand over detailed charges of his seat to Jayanta Kumar Raut. Petitioner before my lord.
Correct.
District
you took charge of that office.
My lord?
We agree that you took charge on that particular date, 30/6/2020.
Yes, my lord.
1 second.
Yes.
You mean to say you are promoted that day itself?
I am promoted on the next day because that day cannot be, two persons cannot work on that same day. Because on 1/7 I deemed to be promoted.
1/7/2020? Where is the promotion order?
Promotion order is after 6 months.
No, DPC order is also not there.
Not there.
Your contention
So
is that even if DPC is not held,
take out the Basavaraj N. Dhotrad. Here is our researcher. Basavaraj N. Dhotrad versus Managing Director. ILR, Karnataka. Maybe 2004, something like that. Basavaraj N. DHOTRAD. Basavaraj. BASAVARAG. Basavaraj N. Dhotrad versus Managing DHO. RAD. Justice, Honorable Justice Nazir's judgment. Managing Director.
No, don't look at the screen.
Only one.
It will give suggestion.
Only one name I remember.
Dhotrad, you can. I don't know any of this. Not everything. The DPC also.
Cannot give it. Correct time. Went to Supreme Court and affirmed also. Yes, Justice Nazir Saab's judgment. But ILR?
This ILR 2006. Karnataka 3163.
ILR 2006.
Karnataka 3163.
3163. One paragraph from Justice Rama Joyce's book, one paragraph is referred there. Or independent charge, in charge. There is one paragraph in that. Read that.
Therefore, he is not supposed to discharge the substantiative functions of the post and office which he holds on in charge basis.
In charge basis.
The services under the state by Justice N. Ramajoy.
Read slowly. Sir, kindly hear to this. This is affirmed by the Supreme.
I take note of it,
Yes.
Promotion to the higher post means the appointment of a civil servant to a higher post on a regular basis, either temporary or permanent in accordance with the rules. In charge, arrangement, and promotion are well understood terms in civil service. Posting an officer in the lower post to discharge the duties of a higher post without promotion is only an in-charge arrangement and it cannot be touted as a promotion.
Yes, this is the law.
My lord, I quite agree with the law, your lordship.
If that is so, how can you see that you should be treated as having been promoted with effect from 1/7/2020, going by your version? What is the basis?
Basis is, my lord, even there are decisions supporting my case.
You give those decisions, but saying that decision supporting, we do not know. We have given a decision now.
I look into it, I come back to your lordship tomorrow.
Tomorrow,
before any other day, your lordship fixes.
It is squarely covered by the apex court decision. Anyway,
maybe I'll try to persuade your lordship to look at it from another angle.
No, the question to you,
sir,
senior, is that suddenly if 2/1/2021 is taken, 2nd January, have you been deprived of anything?
Yes, one increment will go.
Have you been deprived?
One increment will go because it is increment accrues with effect from first day of the new year or last day of the preceding year.
First day
of the new year. Same. Therefore, he will lose one increment. And rightly, he will lose it.
Rightly is the word your lordship may not say no.
Because the Ramadan says that.
And sir, I think you did not state your argument to July actually that day.
I will persuade your lordship to agree with me. Notwithstanding the judgment, your lordship is
tomorrow.
Very kind.
Tomorrow
or any other date, your lordship say.
Whichever. So then first week of August.
Good enough.
Right. First week of
Item 32, next item.
This is not the.
I have not.
My lord. This is not the right time to put forth my grievance. Your lordship was rising. I should have realized that.
Item 32, next item. I have prayed for